Good morning, folks. I'm attorney Roger P. Foley, and today I'm going to answer the question of whether or not you can drive after receiving a DUI charge.
Roger P. Foley, when you need him, Roger P.
If you are charged with your very first DUI, you have two options. You can apply for the waiver program. The waiver program allows you to sign up for a DUI class, pay a $25 application fee, have a meeting at DMV, and waive your right to a formal or informal review of your driver's license suspension. So what do most people do on a first-time DUI? They go right down to the local DMV school, or the DUI school rather. They sign up for the DUI class. They schedule a time to do that. They take that receipt. They go online. They apply for the waiver program through the Department of Motor Vehicle. They pay $25. They fill out a small application. And when they get that waiver program, when they get the hardship license allows them to drive to and from school, to and from work, to and from medical appointments, to and from the grocery store, to and from religious practices. So it's limited. You can't go pick up your boyfriend. You can't go pick up your girlfriend. You can't drive your parents to the doctor. It's for your doctor appointments only, right? So you can drive for medical purposes for yourself only, not your kids, not your significant other, not your other family members, you and you alone. You can drive to and from school or work. You can drive to and from medical. If you go to church, if you go to synagogue, any religious practice, you can go for prayer. You can go to your local grocery store. Now, if you live in one town and there's a Publix right down the street from your house, and you decide to go to a Publix that's 10 miles away in another town, you're probably going to have an issue. You're probably going to get arrested for driving against those restrictions. And on a DUI, that most of the time means jail. So you can acquire a hardship license. Now, that's option one through the waiver program. That's what 95% of people are doing now. Now, I say 95% of people. If you're a driver, if you work for UPS, if you work for FedEx, if you're a truck driver, if you have a CDL, you're probably not going to do that. You're probably going to hire an attorney to do a formal or informal review. A formal review, all that really means is that you're subpoenaing witnesses, the police officers. They're going to come in, they're going to testify. There has to be probable cause for the stop of the vehicle, meaning they have to have good reason to stop you. They have to have reasonable suspicion to begin a DUI investigation, but that's not really argued too much in DMV formal review or informal review hearings. But they have to have probable cause to arrest. So just so you know, if you have bloodshot eyes, odor of alcohol, flush face, that's enough to start a DUI, and that's also enough to arrest. So now the next prong of that is whether or not you gave a breath and it was 0.08 or higher, or if you refused to give a breath. Well, think about it. If the officer had he had a reason to stop you, you were speeding, check, probable cause to stop. The next one, he starts a DUI investigation, but he notices factors of impairment, bloodshot eyes, flush face, odor of alcohol, check. Just on those factors alone, he has probable cause to arrest. Probably not the burden that he needs to convict you in a court of law, but enough to win at a DMV hearing. Next is, did you give a breath or did you not give a breath? If you gave a breath, he's going to say the machine registered, 0.12, right? Or 0.089, whatever it may be. But if it's over 0.08, check, that's it. You don't win. Or if you refuse to give a breath, the officer says, I'm Officer Smith, I swear to tell the truth. And Mr. Jones, I asked him to give him a breath. I read him implied consent, and he refused. Boom, you lose. So the reason why the waiver program is so popular is because attorneys in good faith cannot tell you that there's a high likelihood of victory, right? Is the stop good? Did the officer, in his opinion, based on his training experience, observe factors of impairment that would be consistent with someone under the influence? All that officer has to do is say yes. It's not really objective, it's subjective. He says yes, or did he give a breath, or did she give a breath, or did he or she refuse to give a breath? That's it. And you lose. As opposed to a waiver program where you say, I'm going to waive my right to that hearing. You sign up for the DUI class and you pay $25 and you can drive for the limited purposes that a hardship allows you to drive. So what about a second DUI, a third DUI, a fourth DUI? I had a client that had 8 DUIs. In the case of 8 DUIs or 2 DUIs, you're not entitled to the waiver program, right? So you can't go in and apply for a waiver, sign up for a class, and pay $25. Impossible. You are, however, allowed to have a formal or informal hearing. So informal, basically you go in, your attorney goes in and they argue with paperwork and no live testimony, or formal hearing where they also subpoena the officer. Why would you have a difference? I'm just going to give you a quick, note. Why would you do an informal review hearing versus a formal review hearing? Don't you want to get that officer to testify? Isn't the fact that he testified, can't you get a copy of that recording and use it like a depo in court? Sure, you can. But what if the officer makes a mistake on the paperwork? If you call him in to testify at a formal review hearing and he goes, oh yeah, I forgot to put that. Let me amend that orally, right? And now he says what he needs to say, you lose. But if he makes a mistake on the paperwork, you can go simply on the paperwork. And if the paperwork's not done correctly, you have a good shot at winning that formal review hearing, and the suspension of your license is vacated, and now you can drive and you don't need a hardship license. So that's why. So on a second, third, fourth, fifth, whatever DUI, you're not entitled to the waiver program, but you can have a formal or informal hearing, either calling the officer or not calling the officer, using that testimony possibly to help you on your criminal case. So, hardship license explained. I'm attorney Roger P. Foley. Thanks for listening. Subscribe.
We need to call Foley, man.
You got a charge, the situation tense. You need an attorney for criminal defense. Call RP4